Other side is happier?
Yes, sir.
Some.
Serial 12.
Yes, I am in serial number. I am having the file of serial number 12.
Yes, sir. Most of the respondents are again. Some respondents are as per the office report. Some respondents are also tracked on this function. Respondent number 1 who is also the advocate was aware of the pendency of this advocate serial number. In spite of that, before vacation they started the construction of the and also block the exit part of the drainage of the appellate process. It becomes very hazardous problem. By grade, we want to maintain status quo. Take a decision on this.
The service is not complete.
Some of the respondents have tried.
So,
Most
you have to take steps, no? If there is any obstruction to drainage, you take appropriate steps.
we made an application before the concerned police station also, but the police station refused also because
Refuse, that is a separate cause of action.
we have annexed this.
You see, the service is not complete. Right? There are so many persons who have expired. Right? And this second appeal was filed in 2016. It remained pending at your instance, I do not know at whose instance. The substantial question of law has been framed only in the month of June 2012. Who is responsible for this?
Since most of the respondents have again lost their
बहुत से नहीं होता नहीं
because they are aware of
आपके नेग्लिजेंस के कारण जो है ना कोई अर्जेंसी नहीं आप 2016 से क्या कर रहे थे 10 साल 10 years
इसमें कुछ डिफेक्ट था
कोई डिफेक्ट आपका ऐसे ही पड़ा रहता है जब टेकअप होगा तब सोचेंगे
लोअर कोर्स करेक्शन का आया था
तो 2016 से अभी आया करेक्शन होता है
उसमें हम एप्लीकेशन
2016 से 2025 तक क्या कर रहे थे एक्सप्लेन ऐसे नहीं होगा एंड यू हैव फाइल्ड अ पिटीशन बिफोर द पुलिस स्टेशन आपका ड्रेनेज रोक रहा है तो यू प्रोसीड एज पर लॉ ऐसे नहीं होगा अगर होता ना अगर सर्विस कंप्लीट होता तो हम सुन ही लेते अब आपके पेंडेंसी कोर्ट के पेंडेंसी के कारण या व्हाटएवर बी द रीजन आधे लोग तो मर गए सब्स्टिट्यूट करिए सबको
इसको टेकअप करिए सबमिशन
टेकअप आप सब्स्टिट्यूशन करिए और ये तो आपको पता ही नहीं है कौन कौन बचे
University of the Delhi College. Today, my discussion आज तक स्टे है हमारा. Final
थोड़ा रुक जाइए सीरियल नंबर 3 है ना
Your Lordship, I am the respondent, Your Lordship. I am not prepared about the Your Lordship.
You're not prepared?
Next date एक छोटा सोमवार को दे दिया जाएगा.
हम डेट देंगे लेकिन स्टे कर देंगे
सोमवार तक के लिए.
अच्छा आने दीजिए आप क्यों नहीं तैयार हैं
हुजूर हमको ये जो रिटन आर्गुमेंट शॉर्ट नोट्स करके मिल रहा है. थोड़ा सा देखिए.
अच्छा ठीक है केस टेकअप करो तब देखेंगे अभी ये 10:30 बजे फिक्स किए हैं पहले उसको सुनो
This is from outside of the district. This is a criminal
you don't take mentions my court master has been empowered to allow all the mentions
From several police for item 272
यहाँ पे कोर्ट मास्टर को देने से by default mentions के अलाउ हो जाता है unless there is a reason to refuse he will come to me whether it should be refused
Item
or
2.
I was not aware.
listing of the case is a right of an advocate चेकअप होगा कि नहीं होगा इसका कोई गारंटी है दो सेकंड इसको ऐसे करें ये सारा क्लैप करें और ये भी सारा सीक्वेंस है ठीक है मतलब year of judgments. So High Court का होता है Supreme Court. Yes, please. Give me the foundational facts. Suit under BBC Act. No dispute on this. Default and personal necessity. You have been held to be a defaulter.
Defaulter and personal necessity.
Both the points. Both the points. There is no question of law so far as these aspects are concerned.
No question of
Law so far as these aspects are concerned.
no. The question of default at least would come into play when there is a contract.
No, that is a separate.
Yes, yes.
Otherwise, there is no
No.
question of law. What is the date of tenancy?
Date of
Tenancy.
tenancy according to us it was in 2001.
What is
And
the
according
finding?
to them, same 2002. But
It makes no
one,
difference.
no, it does not.
Sometimes in the year 2001-2002. It is also not in dispute that there was tenancy.
Yes, no dispute.
No dispute on that. According to you, till when did you pay the rent?
Until the date of the agreement. The MOU was entered in 2007.
MOU, kindly give me the date. There are two dates on
Two
it.
dates. First, MOU was entered, and then after approximately 8 to 10
What is
months.
the date of MOU? Sorry?
3rd of September 2007.
3/9/2007. What is the date of agreement?
Agreement is 3rd of October 2008.
30th.
30th.
30/10/2008.
Okay.
As per the MOU, what was the consideration amount?
35.
35 lakhs.
Yes. Out of which I had paid rupees 1 lakh on that date.
Paid.
By way of check. It was paid
That
by
was
way of check.
encashed. There is no dispute on this.
No, this fact of payment of 1 lakh was not stated by them in their name,
That's
but it was stated by us in our, and ultimately in examination, this payment of 1 lakh has been admitted.
okay. So there is, as of now, in second appeal, there is no dispute on that.
On payment of 1 lakh is not in.
Not in this. By the time of agreement, how much was paid?
Yes, 4 lakh.
Plus 4 lakh.
Plus 4 lakh, 1 lakh was acknowledged that earlier at the time of MOU, 1 lakh had been paid. This was acknowledged in the agreement, and then further cash of 4 lakh was paid, and this amount has been mentioned in the agreement. And all these documents,
One more thing. They are all exhibited, there is no dispute on that. One more thing, that according to you, till what date did you make the payment of rent?
till the time of MOU, till the date when the MOU was entered, till the month of September 2007, we have the monthly.
And what is the finding on this? Because they claim that you were
No
defaulter.
finding on this.
No finding on
No.
this. That since when you were the defaulter is not in
No,
there is no finding.
what it says, the question that was, issues were framed at your achievement in the first day.
These are very
Yes,
important
yes,
dates,
yes,
because by giving the dictation, these dates are.
yes.
So I'm just trying to figure it out. According to you, you paid rent till,
September 2007.
and according to you, plaintiff, till what? What is the date of default?
Default January 2004. The amount of rupees 1 lakh was adjusted for the month of entire year of 2003. In December 2003, that 1 lakh was adjusted, and since 2000 January 2004,
And therefore, after adjustment of that rupees 1 lakh, this from January 2004, they became a default. I just want to know from you, is there any finding? What is the date of default?
One more dispute is there, and I must give you. Your Lordship, according to plaint, the monthly rent was 15.
15.
Yes, yes, that has been
15,000.
mentioned in the plaint itself.
15,000.
15,000 per month. Whereas according to us, it was 3,500.
According to you,
3,500.
3,005. Is there any finding on
No.
this? No finding. So, according to you, the date of default, on the date of default, there is no finding.
No.
Nor on the quantum of rent, there is any.
No.
So we can take it that case has been primarily decided on the ground that the defendant had stopped paying rent beyond September. It was an
Yes, yes,
admitted
yes.
fact that beyond September you stopped paying.
Yes, and this point when this default occurred, this has not been taken into consideration, and the agreement itself, entire finding is on the basis that this agreement cannot be looked into.
That's
There are two findings. First by the trial court that because there is, we have admitted that we were tenant, therefore agreement is absolutely irrelevant.
okay.
That is the finding of the trial. Once we have admitted that we were tenant, landlord-tenant relationship was established, and
Agreement is
therefore
irrelevant.
it was irrelevant. And the appellate court, it discards this to look into the agreement itself on the ground that it was unreasonable.
These submissions are correct, or is there any dispute on this? Just take them.
There is no finding in respect of the quantum.
I just give a short description. देखिए second appeal number 72 of 2025. This appeal has been filed against judgment dated 15 February 2025, passed in civil appeal number 10 of 2018. And decree dated 29 February 2025 by the Additional Judicial Commissioner Roman 13 Ranchi, whereby the appeal has been dismissed. The trial court judgment has been passed by judgment dated 29 November 2017 and decree signed on judgment and decree, both dated 29 November 2017 in eviction title suit number 9 of 2009, passed by learned civil judge in bracket senior division bracket close Roman in Ranchi. The suit was filed under the provisions of the suit for eviction was filed under the provisions of Bihar Building within bracket Lease, Rent and Eviction bracket close Control Act. On ground of default in payment of rent and also on account of personal necessity. The suit was decreed on both the grounds and the appeal has been dismissed. Consequently, the defendant is the appellant before the suit. The appeal was admitted by the order dated 10/9/2025 by framing substantial question of law which was slightly modified by the order dated 6/1/2026. Consequently, this appeal is to be heard on the following substantial question of law. 6(1) का ऑर्डर है, थोड़ा सा चेंज है उसमें से. By giving the foundational background, it is not in dispute during the course of argument that admittedly the defendant was inducted as a tenant sometimes in the year 2001-02 and was in possession of the suit property. As per the plaintiff, one memorandum of understanding dated 3/9/2007 was entered into between the parties, whereby the landlord agreed to sell the property to the defendant for a consideration amount of rupees 35 lakhs, and out of which 1 lakh was paid. Full stop. As per the just a moment. The plaintiff has mentioned about the MOU. As per the defendant, okay, not as per the plaintiff. Further, as per the defendant, the MOU was followed by an agreement dated 30/10/2008, and further 4 lakhs was paid out of the consideration amount. As per the defendant, the rent was paid up till September 2007, that is till the date of MOU, till the month of MOU, and subsequently the defendant stopped making payment of rent. So far as the plaintiff is concerned, it was their case that the defendant had paid rent till January 2004, rent till December 2003, and the amount of rupees 1 lakh which was paid by the defendant was adjusted, and consequently the defendant did not pay rent from January 2004. Further, it transpired that, as per the plaint, the rent was rupees 50,000 per month, and as per the written statement, the rent was rupees 3,500 per month. both the councils during the course of argument have found that there is no finding of the learned courts with regard to the date of default in payment of rent. And further, there is no finding as to what was the quantum of rent fixed with respect to the tenancy. However, initial tenancy is not in dispute. The councils have also submitted that the case has been decided primarily on the ground that the defendant stopped making payment of rent. Defendant admittedly stopped making payment of rent from September 2007. इतना तक तो एडमिशन है ना डिपेंडेंट और केस भी उसी ग्राउंड पर डिसाइड हुआ है, करेक्ट? And therefore, non-payment of rent by the defendant stood admitted on record, at least beyond September 2007. It has been submitted by the Learned Counsel for the Appealant that the agreement which was entered into between the parties has not been considered by the Learned Trial Court on the ground that there was admission of relationship of landlord and tenant between the parties and such an agreement was irrelevant. He has also submitted that the appellate court has recorded that the agreement being an unregistered document could not be relied on. And consequently, the aforesaid substantial questions of law have been framed to be decided by this court.
The personal necessity is and second, that this is an agreement. They mentioned that pursuant to the agreement or the agreement, the possession was they came in possession part of form.
You see, इतना तो admitted factual background हो गया.
WS के हिसाब से बता रहे हैं.
अच्छा, as per the WS.
As per the WS, they say that after the coming into force of the agreement to say or the MOU, they continued in possession part of forms of the contract.
Okay. It has been pointed out by the Learned Counsel appearing on behalf of the respondent landlord that as per the written statement, it was the specific case of the defendant that pursuant to the MOU/agreement for sale, they continued in possession of the property in part performance of the contract, and therefore they were not liable to be evicted. एक चीज एक सूट चल रहा है, आपका सूट का नंबर बताइए.
474/2009, title suit 474/2009, which is at the stage of evidence of the plaintiff, which is assessed performance of suit, which is filed by the defendant.
Of this agreement only.
Yes.
Is that correct? It is also an admitted fact that a suit for specific performance of contract has been filed by the defendant with respect to the agreements and has been numbered as title suit number 474/2009, and the same is pending for evidence of the present defendant, who is the plaintiff in this case.
Only correction on that it is running for evidence of defendant and not
Close हो चुका है, plaintiff कब शुरू होगा? ये close. जो भी मेरा evidence है.
At the stage of evidence खाली
ठीक है.
खाली at the
नहीं
stage of
plaintiff's evidence here.
कोई बात नहीं, यहाँ कुछ नहीं
ठीक है.
है. Plaintiff evidence बात नहीं है. At the stage of evidence. जहाँ controversy है उसको.
नहीं controversy नहीं. ठीक है.
कोई बात नहीं. It is irrelevant. The fact
नहीं,
is that
वो
the
नहीं.
suit is pending.
He could not have started evidence because it was my suit, specific performance.
That's
So I would start. He could not, in my suit, he could not have started evidence.
That's
Defendant.
अब चलिए. अब आपको बिना डिस्टर्ब किए, अच्छा एक चीज और, I would like to place at this stage. The learned counsel for the appellant has submitted that he would be relying upon following judgments with respect to the substantial question of law involved in this case. Like
तो एक उसमें हम कर रहे हैं, एक जो सुप्रीम कोर्ट का है,
साइटेशन पैरा दोनों बताइए, फिर आपका भी लिखेंगे, ये नहीं बताइए कौन सा? ऐसे 80,011 का चेक करें, ऐसे 80,2011 decided on 26/2020. जजमेंट का लिस्ट बताइए, पैरा बताएंगे तो हम उसको डालेंगे। आप भी अपना लिस्ट कर लीजिए।
I'll be relying particularly in paragraph 6.
6 of
6 of this judgment is 2000, volume 9 SCC, page 339.
इसको लिखिए, he has relied upon bracket 2000 bracket 9 SCC 339 R Kantimati and others versus Beatrix Xavier. Paragraph number
6 and 6, 7 and 8.
paragraph number 6, 7 and 8. इसको कोट कर देंगे. Okay. And anything else?
There is another judgment, this only 2-page judgment, this whether an agreement for sale is required to be registered.
उसके बाद next लिखिएगा bracket 2007 bracket 15 SCC 783 with the bracket Moolchand and others versus Nanagram and others.
Verify.
Paraphrase. ठीक है? That's all. और तो कोई जजमेंट आपने रिलाई करनी? आप बताइए।
सरकार ये जजमेंट सिर्फ ऐड कर रहा हूँ और ये मेलॉट का जो एक जजमेंट है और ये सेकंड अपील ऑफ उसी लाइन पे कंट्रोल सुप्रीम कोर्ट का भी सेम लाइन का जो मैंने तो ऑब्जर्वेशन उसी लाइन पर कि उसका गवर्नमेंट देखना है उसी लाइन पर अपने सुप्रीम कोर्ट का भी एक लाइन सेम लाइन
यही है जजमेंट।
ये जजमेंट है बट हम उसको खाली मैलॉट का जजमेंट था सब उसको डिस्टिंग्विश करने के पर्पस से ही हम ये जजमेंट दे रहे हैं दोनों सेम लाइन पर मैलॉट का जो व्यू है सुप्रीम कोर्ट का
The counsel for the respondent on the other hand is relying upon the following judgments. ये आपने पूरा बंच दिया है। One report one है 1999 with bracket 2 PHR 189 para 4 then 2003 with bracket 1 JLJR 592 2004 Then 2009, within bracket 3, bracket close JLBI 19, para 5 and 8. Bracket 2012, bracket close 1, SCC 656, para 16, 18 and 19. In 2018, bracket में रहेगा 4 JCR 273 with bracket DHR, para 13, 20 to 32. Bracket 2022, bracket close 13, SCC 756. Para 11 and 12. Then AIR 2025, SC 2933. Para 9, 9.2, 9.3, 9.4 and 9.5. Serial bill number 4484 of 2025. Within that is Somnath versus Ravindra Kumar. Decided on 25th of March 2025. Para 13 and 14. So, name, finding SLP name. So SLP name. 80 वाला है, so SLP name. Bracket 2019, bracket use 4 SCC 153. Para 22, 23, 29, 30, 31, 32 and 33. And bracket 2018, bracket close 7 SCC 646. Para 18, 19, 20, 21 and 20. ठीक है?
1999 का
बताइए, छूट गया क्या?
1999 2 years है 189.
वो तो पहले ही लिखा था, वो सीक्वेंस में है।
I'm sorry.
All these elements have been placed in sequence. ये जो अभी एक पन्ना का जर्नल दिया तो इसको इसी में yes please now you ये सारी चीजें इसमें रहेंगी नीचे
Can I start with the plaint itself?
yes you can start in any manner you want. Yes.
First para it says that the plaintiff will be owner and lady is also, and the defendant is a month-to-month tenant with respect to the premises on a monthly rent of the 15th. And then, suit clause was allotted, all these facts are not in dispute. Then, para 5, the defendant was a habitual defaulter in payment of rent. He paid rent up to December 2003 and thereafter, in spite of repeated requests, the defendant neither paid rent nor he validly tendered the same. This is very important for a point of subsequently why. Now, the complaint itself says that he paid rent up to December 2003. So, the complaint assumes that I have already paid rent, I have continuously till December 2003 I have already paid. And thereafter, in spite of repeated requests, the defendant neither paid rent nor he validly tendered the same. As a matter of fact, the husband of plaintiff left merchant taking advantage of his absence and his ill health, the defendant completely stopped paying rent. That when, after repeated requests and letters of defendant did not pay rent to the plaintiff sent a legal notice to the defendant on 23/10/2009 under registered cover under so and so, and it clearly mentions. And then grounds for personal necessity have been mentioned. Then para 9, the defendant has also rendered himself liable for eviction on the ground of non-payment of rent since January 2004. And then obviously ground of default and prayer for eviction on the ground of relief claim is that a decree be passed against the defendant for his eviction from the suit premises, fully described in Schedule B. So this was essentially my contention would be a suit under the provisions of PVC Act. This fact cannot be disputed. And one more fact, which my learned friend has pointed out, para 3, it mentioned that original landowner, that means husband of the plaintiff, had died on 10th of March 2000. This state would be also be. Now we file a written statement. Our content statement made in the written statement is that. Para 6. That there is no relationship of landlady and tenant between the plaintiff on one hand and defendant on the other hand, and as such the provision of the Bihar building so and so is not maintainable, the suit is liable to be dismissed on this ground alone. And then we have mentioned our statement in para 7 onwards, where we say that the defendant was inducted as a month-to-month tenant.
Para 7.
Para 7. Just next page, para 6.
The Roman number.
Para 7-1. 7. The defendant was inducted as a month-to-month tenant with respect to the suit premises, along with their land so and so, all the description is there. With respect to the suit premises by Satyendra Kumar Sinha, husband of plaintiff, since 15th of January 2001, 1 month, on a rent of rupees 3,500 only per month. This I place because there is a dispute as regards the monthly rent also. The defendant regularly paid rent to Satyendra Kumar Sinha. Satyendra Kumar Sinha intended to sell the suit property, and with negotiation with the defendant, the consideration money for purchase of the suit property was fixed at rupees 35 lakh only. Accordingly, a memorandum of understanding was executed between the said Satyendra Kumar Sinha and defendant on 3rd of November 2007, which was duly notarized by SEMS. By virtue of the said memorandum of understanding, Satyendra Kumar Sinha undertook to sell the suit property for a consideration of rupees 35 lakh only. The defendant paid an advance of rupees 1 lakh only through account pay check on account of so and so on 8/10/2007 of Bank of Maharashtra in the name of Ajit Kumar Sinha, the power of attorney holder of Sri Satyendra. He is the same power of attorney holder of the plaintiff. The power of attorney holder of Satyendra Kumar Sinha, as per the direction given by Sri Satyendra Kumar Sinha, the said check was encashed and the amount of rupees 1 lakh only by way of advance was received by Satyendra Kumar Sinha by virtue of the said memorandum of understanding, and the agreement for sale was required to be executed between Satyendra Kumar Sinha and the defendant. And subsequently, an agreement for sale of suit property was executed between the Satyendra Kumar Sinha and the defendant, executed on 30/10/2008 in pursuance of the earlier memorandum agreement dated 3/9/2007, incorporating the terms and conditions. By virtue of the said agreement for sale, Sri Satyendra Kumar Sinha acknowledged receipt of rupees 1 lakh only as advance from the defendant under the memorandum of understanding dated 3/9/2007, and received further advance of rupees 4 lakh from the defendant. That by virtue of the said agreement, Sri Satyendra Kumar Sinha undertook to execute and register the sale deed in favor of the defendant on or before 3/9/2010, after receipt of balance concession money amounting to rupees 30 lakh money. That by virtue of the said agreement, defendant was not required to pay rent of the suit premises to Satyendra Kumar Sinha, and the defendant defendant is continuing in possession in part of performance of the said agreement to sell, and the right of the defendant to continue in possession of the suit premises in part of performance of the agreement as aforesaid. That Satyendra Kumar Sinha unfortunately died issued as on 10/3/2009, leaving behind the plaintiff as his sole widow and legal heir. After the death of Satyendra Kumar Sinha, the defendant requested the plaintiff to receive the balance concession amount and to execute and register the same in favor of the defendant, but the plaintiff refused to execute and register the sale and started threatening the defendant to vacate the suit premises in which the defendant is residing with his family members same source. But the defendant was all along ready and willing, all these contentions are there. And then next page here, which I have mentioned that on failure to do so, the suit was filed. In internal page, where I have mentioned that the suit and the defendant has been compelled to file a title suit number 474 of 2009 against the plaintiff before the learned court, claiming a decree for specific performance of memorandum of understanding dated so and so and the agreement for sale dated so and for directing the defendant, who is the defendant, to execute and register the sale. Now, next paragraph 8 is there. Again, it is the monthly rent was 50,000. This has been disputed, and only rent was 3,500. And other portions are essential facts. These are the only essential. Otherwise, there is a denial of landlord-tenant relationship. And then now, before I proceed to the impugned judgments of both the courts here, Your Lordship, if Your Lordship would kindly see the two memorandum of understanding and the agreement and then other evidences, then it would be clear as to how the trial court has discussed all this. Trial court as well as the appellate. Those two exhibits are, yes. AMB.
Exhibit
AMB.
Exhibit A.
Yes.
A is MOU.
MOU.
And agreement is?
Agreement is B. It says, I will be allowed to read out the MOU itself. Then I will place the relevant portion of it. Today, that is the 3rd of September, so and so, memorandum of understanding made between Pawan Kumar Jaiswal, son of so and so and so and so, and Shri Satyendra Kumar Sinha, who is the landowner. That the first party is in possession of over the plot number so and so as tenants in 15th of January 2001 of the legally allotted owner, second party, and regularly making payment of monthly rent at the rate of 3,500 per month to the second party, and is willing to purchase this said plot with building and fixtures if the second party desires to sell the same. That the second party admits and accepts that the first party was given in possession as tenant on 15th of January 2001, and the monthly payment is being made regularly. So, on the date when this agreement MOU was entered, the landowner acknowledges that I have continuously paid. That the second party has assured the first party earlier verbally that if the second party shall sell the said plot number so and so with building and fixtures, then the first party will be asked with preference. Now the second party is in need of money for treatment and other requirement and decided to sell the said plot with building and fixtures at a cost of 35 lakh only. That the first party agreed to pay the valued amount of 35 lakh only as advance handed over account pay check of so and so, dated so and so, issued only as per the direction of the issued by the first party in favor of Ajit Kumar Sinha as per direction and wish of the first party. That the second party accepted the said check and directed the first party to make at least 10% of the total value amount 35 lakh as advance, then only a document of agreement to sell will be executed and further the total amount must be given to the second party within 3 years from today on these terms and conditions. This MOU shall be binding on the parties and its successors, and if required, the amount shall not be paid or check accepted by the first party today shall not be encashed. Then the first party shall be treated as tenant, and on the monthly rent of rupees 5,000 shall be recoverable from the first party after 15/10/2007, and this MOU shall stand cancelled. This ultimately, this is only. This ultimately culminated in a binding agreement. Therefore, that would be more. But here are only MOU in terms of conditions have been met. So, according to this MOU also,
You read this 5 months ago, that the second party accepted the check.
accepted the said check, that the second party accepted the said check and directed the first party to make at least 10% of the total value amount of 35 lakh rupees as advance. So 10% would be 3 lakh 50 as advance. Then document of agreement to sale shall be executed and further the total amount must be given to the second party within 3 years from today. That means 3 years from 3rd of September 2007 till the 2010. So this time was there. From today on this term and condition, this MOU shall be binding on the parties and its successors, and if required, the amount shall not be paid or check accepted by the first party today shall not be encashed. Then the first party shall be treated as tenant and monthly rent of rupees 5,000 shall be recoverable from the first party on 15/10 after 15/10/2007, and this MOU shall stand. So I'll pause, I'll explain what is there. Now, if the check, the MOU itself says that if the check which you are paying 1 lakh, if that is not encashed by me, then this MOU has absolutely no value. So this is, and you are.
MOU was subject to encashment.
Yes, absolutely. I cannot shy away from that.
One could have simply not encashed.
Yes.
Irrespective of being bounced or not.
Yes. Now this is actually encashed. So then it ultimately culminates in the agreement itself. Therefore, all these facts have been.
Encashment of check is not in dispute.
No. Now what they say, this fact.
I just wanted to know. This
No,
check was encashed.
Encashment is not in. This is the amount which they now say that this is the amount which they have adjusted for the month of June 2003 to December 2000 at the rate of 15,000. So even if that is calculated, it comes to 1,05,000, not 1 lakh. Even if their contention subsequently is accepted, then your check ultimately culminates in the agreement, which is agreement for sale of immovable property. This is dated 30th of October 2000. And this is very important. This is the most important document on the basis of which rights to be dependent.
This is Exhibit B.
This is today 30th of October 2008.
Yes.
And most important fact would be this agreement has been marked without objection. Absolutely without objection. The objection was with regard to marking of MOU, but not with regard to this. In evidence in oath this entire statement with regard to agreement was mentioned and the document was proposed to be marked, which was marked without. Then today, that is 30th of October, so this agreement for sale of renewable property is made between Satyendra Kumar Sinha and Pawan Kumar Jaiswal, whereas other terms. Then next page may kindly be seen. Whereas the first party has constructed one pakka house over so and so and handed over the said house to the second party on 15/1/2001 on monthly rent of rupees 3,500 verbally as tenant, whereas the second party is deciding and maintaining the said house and regularly paid monthly rent in cash to the first party till September 2007 without obtaining any receipt from the first party. However, this fact has been admitted and accepted herewith, whereas it is admitted fact that the first party has never issued any receipt after receiving monthly rent, earlier assured verbally to the second party that if at any time the first party would desire to sell the said plot number so and so with house and picture, preference shall be given to the second party. Whereas on 3/9/2009, first party made an MOU and expressed the desire to sell the said plot with house and fixtures at total cost of 35 lakh only to the second party, and the second party accepting the proposal on 3/9/2007 handed over an account paid check number so and so dated 8/10/2007 of rupees 8 1 lakh of Bank of Maharashtra on the direction of the first party payable to one Ajit Kumar Sinha, a faithful person of first party, who encashed the said check on 8/10/2007 itself and withdrawn rupees 1 lakh from the CCA account number so and so of the second party and handed over the said amount to the first party is an admitted fact and affirmed by the first party hereto. Whereas as per the terms of MOU dated so and so, the MOU shall prevail further only after an encashment of rupees 1 lakh from the account of second party before 15/10/2007, since the terms have been fulfilled by the second party within the prescribed time, and further terms of payment of 10% total cost agreed between the parties have been subsequently paid rupees 4 lakh only as advance by the second party to the first party in cash. This and the said amount has been received by the first party from Ajit Kumar Sinha. It is accepted and affirmed herewith. It is made clear this portion is the most important. And it is made clear that after September 2007, the monthly rent of the said premises shall not be chargeable from the second party as advance amount against the total cost of premises of block number so and so with house and picture has been received by the first party, and the second party has made maintenance cost to the services housing cooperative society by account pay check in the account of so and so in the name of the first party. Very clearly it stipulates that no further monthly rent shall be paid. After that, accepting the aforesaid fact, both parties agreed to execute the agreement to sell on the following terms and conditions. Again, the first term is important, that the remaining amount of 30 lakh, again the total cost of 35 lakh, plot number so and so must be paid on or before 39/2010. To the first party by the second party, and the property shall be legally transferred on payment of full and final payment immediately thereafter, and then other conditions are there. Then next page, para 6. That if the first party declines to sell, he will return or accepted amount with so and so to the, and if the second party declines to purchase the property, then he has to pay monthly rent at the rate of 10% per month from October 2007 till the date of vacation of so and so, that both parties have understood. Now, what happened is that the time till that date was
Just one correction, the agreement to sale which my senior has referred as exhibit B. Now this is exhibit E, not exhibit B. Exhibit E. And this is with objection.
Okay. अगर विथ ऑब्जेक्शन है हम क्लियरली देख लिए हैं विथ ऑब्जेक्शन नहीं फर्स्ट बिकॉज ही हैज पॉइंटेड आउट दिस the Roche may kindly directly take up the evidence of the parties. Oral evidence by which the document itself was marked. This document was marked by DW4 Sanjay Kumar.
Pawan Kumar.
नहीं, Sanjay Kumar is the witness who had got this marked as an example.
DW4.
DW4 Sanjay DW Sanjay Kumar is the और पीछे लिखा होगा
संजय कुमार सबसे लास्ट में एग्जामिन हुआ कितना है
DW4 है संजय
DW4 संजय
Lordship may directly come to para 5. यह कि लिखित इकरारनामा दिनांक इतना के निष्पादन के दिन प्रतिवादी ने 1 लाख रुपए का चेक so and all these statements of fact is there. Then last 4 lines of prior to para 6. दिनांक 30/10/2008 के लिखित विक्रय इकरारनामा में बतौर गवाह अजय सिंह राज तथा मैंने अपना हस्ताक्षर बनाया जिसे मैं पहचानता हूँ मेरे हस्ताक्षर लिखित विक्रय इकरारनामा में है जो प्रकाश भी अंकित किया जाता है
सिग्नेचर को प्रूव कर रहे एक्सपेक्ट the signature in the agreement which is marked as exhibit B. Now we have finally seen PW6 also. Pawan Kumar. Now we take page number 6, para number 9.
Pawan Kumar.
Page number 6. मेरा ये डॉक्यूमेंट में भी लिखा हुआ है
लेकिन मार्किंग बेसिस होगा ना पेज नंबर 6
स्टार्ट होना है पेज नंबर 5 से
इसको दे पाएंगे
यह पेज नंबर 5 का नंबर 9 यह कि यह मूल लिखित तकरारी जमीन का विक्रय करने के लिए एक करारनामा है जिसको निष्पादन सत्येंद्र कुमार सिन्हा ने दिनांक 30/10/2008 को मेरे पक्ष में किया इस मूल लिखित इकरारनामा को सत्येंद्र कुमार सिन्हा के अधिवक्ता ने ड्राफ्ट किया तथा सत्येंद्र कुमार सिन्हा ने खुद टाइपिस्ट लिखित दलजीत सिंह से मेरे नाम से करवाया था तथा टाइपिस्ट होने के बाद पूर्ण रूप से पढ़कर समझकर 4 लाख रुपए अपने भतीजा अजीत कुमार सिन्हा से प्राप्त किया था तथा अजीत कुमार सिन्हा ने अपने सत्येंद्र कुमार सिन्हा को सुपुर्द किया था। सत्येंद्र कुमार सिन्हा पूर्ण रूप से संतुष्ट होकर लिखित इकरारनामा मेरे सामने प्रत्येक पृष्ठ पर अपना हस्ताक्षर किया। मैं भी अपना हस्ताक्षर प्रत्येक पृष्ठ पर बनाया जिससे मैं पहचानता हूँ। इस प्रकार गवाह अजय कुमार सिंह तथा संजय कुमार सिंह ने मेरे सामने अपना हस्ताक्षर बनाया जिससे मैं पहचानता हूँ तथा सत्येंद्र कुमार सिन्हा ने अधिवक्ता ने भी अपना हस्ताक्षर बनाया तथा नोटरी पब्लिक विभूति कुमार दरद ने भी लिखित इकरारनामा के पृष्ठ पर के पीछे अपना सर्टिफिकेट मेरे सामने दिया जिसके लेखाओं तथा हस्ताक्षर को पहचानता। इस पूरे दिनांक 20/10/2008 के लिखित विक्रय इकरारनामा प्रदर्श ई विद ऑब्जेक्शन लिखित किया जाता है।
ठीक है, I stand corrected. He is right.
Therefore, not I interpret it. Sorry.
ठीक है, I stand corrected. I was under the impression that only authentication portion mentioned in the agreement is have been marked.
Exhibit A was with objection.
Yes.
Exhibit E was also with objection.
Yes, the agreement also. But now let us come to the both the judgment. Both the judgment have not gone into this question at all. They have treated this that there is an agreement between the parties, but despite the agreement, I do not have. This was first I will place the trial court. Running page 48 is the issue where starts from
Yes.
41, but relevant is running page 48 where issues have been mentioned. Issue number 3 onwards, we kindly receive. Whether Satyendra Kumar Sinha, husband of plaintiff, inducted the defendant as a tenant with respect to the suit premises on monthly rent of rupees 15,000 and after the death of Satyendra Kumar Sinha, the plaintiff being widow inherited the property. So the question was whether I was inducted as a tenant in the suit premises on a monthly rent of 15,000. So this was a question which was required to be answered because the parties were at dispute with regard to the rate of rent also. And then whether the defendant defaulted in payment of rent from January 2004 with respect to the suit premises, whether bona fide requirement is there or not. 6 is very important. Whether Satyendra Kumar Sinha intended to sell the property that to the defendant for a consideration of rupees 35 lakh and accordingly a memorandum of understanding was executed between Satyendra Kumar Sinha and defendant on 3/11/2007 and paid rupees 1 lakh to as advance. This was the question, and then the
Issue number 3, 4, 6 and 7.
yes,
Right?
yes.
Correct. What is the finding?
And the finding starts from page 50. No, the
51.
police says the finding starts from page 51. Issue number 3, 4 and 5. And your lecture may kindly see the consideration of the trial. Section 2 so and so defines landlord, entire section 2 quoted. Then the one paragraph is there. The defendant has admitted in written statement that he was inducted to month tenant with respect to the suit premises. Satyendra Kumar Sinha inducted the defendant as tenant on 15/1/2001 the plea of the defendant that he entered into an agreement with Satyendra Kumar Sinha to purchase the suit premises for a concession amount, money amounting to rupees 35 lakh. He paid advance money to Ajit Kumar Sinha, who was attorney holder of Satyendra Kumar Sinha. Rupees 1 lakh was given to so and so, and the defendant filed a title suit so and so. Again, then section 11 is again quoted. First section 2 quoted, then section 11 quoted. Entire second other page is section 11. Entire section 11 has been quoted till page 54. Then the again the finding starts from page 54, that means internal page 54. The plaintiff has claimed the suit premises for eviction on the ground of personal necessity and defaulting payment of rent. The defendant has already admitted in his written statement that he was inducted as a tenant by Satyendra Kumar Sinha and he has been paying rent at the rate of 3,500 per month. He stopped payment after entering into an agreement with Satyendra Kumar Sinha. Now the question arises whether the present suit and the suit filed by defendant against the plaintiff bearing title suit number 474 of 2009 be considered together. The matter was already heard by this court and the court passed an order on 3/12/2014 that both suits are different and the prayer of the defendant to hear and decide both cases together was rejected. The Honorable High Court passed an order directing the trial of so and so to dispose of within 6 weeks. When these two cases are different and the present suit relationship of landlord and tenant has already been established, including the fact that the defendant defaulted in payment of rent, the plea of the defendant plaintiff that he requires the suit premises for his personal need on the ground of good climate of Ranchi in comparison with Siman appears reliable and bona fide, and in this circumstance the issues went in favor. This is the finding.
What about 6 and 7?
And then 6 and 7, next page, next paragraph, you can see. The fact of payment of 35 lakh to Satyendra Kumar Sinha by defendant under the agreement of sale is a matter of fact of title suit number so and so, and this court has got no jurisdiction to impart on this point, and hence the court is restrained himself to comment on this. The matter of agreement for sale of the suit property between Satyendra Kumar Sinha and defendant is also a fact of title suit and requires no comment. This was absolutely against the law laid down by our courts.
So there is no discussion regarding the consequence of the agreement.
No, absolutely. And the question number 6, issue number 6 has not been answered. Whether there was any agreement or not, at least that was absolutely essential for the purpose of deciding whether my right as a tenant, I was still a tenant, or I had my rights as a purchaser I was in possession. This has absolutely not been answered. Then, question number 6 is there. Whether Satyendra Kumar Sinha intended to sell the property and that too for the defendant for consideration so and so, and accordingly a memorandum of so and so was. So whatever may be the consequence of specifically that suit, but this was essential for deciding whether I was still a tenant or after the execution of the agreement.
So the fact as to whether you were required to make payment of rent after the agreement, which was framed by issue number 7, has not been decided.
No, absolutely not. The court simply discards it that this matter cannot be looked into in this. Whereas the Honorable Supreme Court says that this is an agreement. By agreement, the parties change their status from landlord tenant to.
Although the court has framed an issue
Framed
as
an
to
issue.
whether after the agreement defendant was not required to pay rent.
Yes, but it does not absolutely declines to go into that question. My submission would be that whether specific performance suit will be decreed or not, that would be a matter of question in the another suit. But whether I was still a tenant or not, this was absolutely an essential question which was required to be answered by the trial court, which it formulates but does not answer.
What holds you defaulter?
Yes, and no finding on whether what was the rent of payment of rent, whether it was 15,000 or not, whether it was 3,500. So
No finding as to how much was paid, whether it was 1 lakh or 5 lakhs.
No finding whatsoever. This is the only finding, and major portion of the finding is quoting section 2, section 11 and all.
What about the appellate?
Yes, appellate court you should be very the issues have been mentioned in, it starts from page 24, running page 24, the court, appellate court mentioned what were the issues and all the other exhibits and details have been noted down. And then point for determination is at page, internal page 10, running page 20. The question, para 10, the question itself, it may be seen, whether in view of alleged unregistered agreement to sell in favor of the applicant, there subsists any relationship of landlord and tenant between the respondent and the applicant, and then all the discussions are there, which witness said what. Then page 32, running page 30. It would be better if from 31, page 31 itself, I'll read paragraph. Internal page 30. The appellant has claimed that during the lifetime of
You read from this, it appears that the plaintiff responded.
yes.
Page
Second paragraph of page
Yes.
30. Yes. It
This is
appears.
also a finding, I think.
Yes.
Yes, please. read it.
Yes. 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 In fact, the first para itself, I think.
Yes.
The witnesses examined on behalf of the applicant defendant have also stated that husband of the plaintiff had given the suit property on rent to the defendant with regard to the rate of rent of the suit premises. The witnesses, however, have stated that the rent was rupees 3,500 per month. It appears that the plaintiff respondent has claimed that the rent of the suit property was 15,000, whereas the defendant applicant has claimed that rent of
Just a minute. अभी पूरा डिक्टेशन आप लिए हैं, जो भी लिया उसको बोलिए टाइप करें, जितना भी एकदम क्लियर डिक्टेशन है टाइप करें.
It appears that the plaintiff respondent has claimed that the rent of the suit property was 15,000, whereas the defendant applicant has claimed that the rent of the suit premises was rupees 3,000 per month. However, the admitted position is that there was no documentary evidence available to show the rent fixed. From perusal of plaint, it appears that the respondent has not claimed areas of rent. In such position, the quantum of rent, whether it was 3,500 as claimed by the applicant or it was 15,000 as been claimed by the respondent, is of least relevant. From the above material, it is clear that the husband of the respondent was the owner of the suit premises, and after his death, the respondent is the owner of the suit premises. It is also admitted that the husband of the respondent had inducted the applicant as tenant in the suit premises. The applicant has claimed that during the lifetime of the husband of the respondent, the appellant and the husband of the respondent had entered into a memorandum of understanding, pursuant to which an agreement was entered into between them for selling the suit land. As per the terms of the agreement, the applicant had paid rupees 1 lakh by check in the name of Ajit Kumar Sinha, who was the power of attorney holder of the husband of the respondent, and also gave rupees 4 lakh in cash. As such, he being the prospective purchaser, the relationship of landlord and tenant ceased. In support of his claim, the applicant took reliance on memorandum of understanding dated 3/9/2007 and the agreement for sale dated 30/10/2008 as Exhibit A and E respectively. It has been submitted on behalf of the applicant in view of section 53A of the Transfer of Property Act. The respondent is not entitled for a degree of eviction. With regard to the alleged agreement to sell, it has been claimed by the applicant to be a forged document. So far as the check of rupees 1 lakh, it has been claimed that the same is regarding areas of rent. Section 53 of the Transfer of Property Act speaks about part performance as per the said section so and so. But whatever my contention is there with regard to 53, I will defer. My submission will be
Just taking a leave for a second. Just taking a leave for a second.
That's your choice.
para 14. After 53 has been quoted, learned counsel appearing on behalf of the applicant has put reliance on the decision of this Honorable Supreme Court, reported in so and so, wherein the Honorable Supreme Court has said so. Placing reliance on the aforesaid judgment, it has been submitted that since there is no relationship of landlord and tenant between the respondent and the applicant, the suit for eviction under the Jharkhand building so and so is not maintained. This is my main submission.
This judgment you have cited, no?
Yes, this is the same. Placing reliance on so and so, it has been submitted that since there is no relationship of landlord and tenant with respondent, the applicant, the suit for eviction under the Jharkhand Building Act is not. This would be my main submission. On the other hand, it has been argued on behalf of the learned counsel for the respondent that the alleged agreement Exhibit E is an unregistered document, and in view of Section 49 of Registration Act, the said document is inadmissible in evidence, and no reliance can be placed on the said document. Section 49 of the Registration Act deals with the effect of non-registration of the document required to be registered. As per the said section, no document by section 17 or by so and so shall be registered, is so and so to be registered shall affect. That means it is compulsorily these documents are required to be registered. Section 17 says. Then, learned counsel appearing on behalf of the respondent has put reliance on. I'll read entire or
No, whatever you want.
yes. Then para 17. The appellant has disputed the landlord-tenant relationship between the husband of the respondent and himself on the strength of an unregistered agreement to sell. However, sale agreement is compulsorily required to be registered, and if the same is not registered, then as per section 49 of the Registration Act, it cannot be received as evidence of any transaction affecting the property or conferring such power. Though it may be received as evidence of a contract in a suit for specific performance of so and so, in above position, the unregistered agreement cannot be read in evidence in the present proceeding. Accordingly, in absence of evidence of the relationship of respondent and appellant remained that of landlord and tenant. In the above, the matter of ratio of so and so is not applicable to this. It appears that the respondent has filed the suit on the ground of default and so, then this is the main finding which I am challenging. Now here
Yes.
Here, the appellate court misconstrues section 17 also, section 49 also, and 53.
section 17,
Section
49,
and
Of Registration Act.
53A of TPA. Now,
and 53A of.
I'll directly first answer the first question, whether this document is compulsorily registered with the document. Only if a document which is compulsorily registerable and it is not registered, then only the consequences of section 49 would come. Otherwise not. If the document is not compulsorily registerable document, then 49 has got nothing to do.
That's it. If section 17 is attracted, then only
Then
49.
only 49 would come. So here I'll
They have
show.
quoted section 17.
Yes, 17 has been quoted, but it would be better that
Right.
I read from the
Registration Act.
act itself.
Section
17. First 17.
Yes, I'm there.
Yes. Documents of which registration is compulsory. The following documents shall be registered if the property to which they relate situated in so and so and so. Or this act comes in, namely, what are the documents? Instruments of gift of immovable property, other non-testamentary instrument which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of a value of ₹100 and upwards to an immovable. Second is non-testamentary instrument which acknowledge the receipt of payment of the constitution or creation of so and so, lease of immovable property from year to year exceeding 1 year, and other non-testamentary instrument transferring or assigning any bequests also. And then 1A was inserted in this section 17 by amendment of 2001. 1A was with regard to what would be the effect if a document which is where the party is seeking reliance on section 53A, then what would be the consequence of non-receipt? So here.
When you need 1 year also.
Yes. 1A, yes. The document containing contract to transfer for consideration any immovable property for the purposes of section 53 of the Transfer of Property Act shall be registered if they have been executed on or after the commencement of the Registration Act of Amendment Act 2001, and if such documents are not registered on or after commencement, then they shall have no effect for the purpose of section 53A. This is the concept. Here, if the document which is required to be, if possession is being transferred or a party is claiming possession on a property on the basis of an unregistered agreement to sell, then I cannot take shelter of 53. This is one. So here, whether this particular document itself was required to be registered or not, this would be essentially a question which is required to
The
be.
first question would be whether you are seeking the help of section 53A.
I'm not first.
Because as per your written statement and has been pointed out by the respondent, you are seeking the shelter of section
53A comes after the suit is maintainable. If the suit itself claiming that the suit itself.
Relationship is independent of 53A.
Yes. So here is a question where the suit is filed under the DBC Act, claiming that I am a tenant. If the suit itself is not maintainable, then there is no question of my claiming my right under section 53. I would claim my right under 53A would come in a regular suit when they seek recovery of possession in a properly constituted suit, and then I say that on the basis of this agreement I am in possession, and therefore here the suit itself is on the base premise that there is a landlord-tenant relationship. It is not on the premise that there was an agreement but the agreement was unregistered and you were put in possession, now you cannot take shelter of such a. So if the suit itself was not maintainable, these further consequences would not.
According to you, the suit was not maintained
Not
on account
maintainable.
of absence of relationship of land.
Yes, absolutely. The moment there was an agreement, then there was the relationship of landlord and tenant ceased, and the relationship was agreement holder purchaser, proposed purchase.
So therefore, in all cases wherever there is an agreement of sale, then under such circumstances the relationship ceases according to you.
It was seized, particularly when the agreement itself mentions that here we have read the clauses. I had read the clause where the agreement, the landowner himself is recognizing that till date I have paid and now you are not required to pay. If that clause would not have been there, absolutely I would have been deemed to be a tenant and I could not have taken shelter.
Now your judgments.
Yes, Judge. It is only a few paragraphs. I will
You
be
first read 2007-15.
Yes,
And
that
say,
is
and
it.
whether
Yes,
it is compulsory
yes,
to
yes.
register.
That is the 2007-15 SCC 73. And in a civil suit, a document dated so and so styled as an agreement. First, para 2 itself run. Styled as agreement was sought to be tendered in evidence. It is executed on a stamp paper, but it is not registered. The admissibility of the document was objected to by the opposite party, submitting that the document was compulsorily registrable. As was not registered, it was inadmissible in evidence. The objection prevailed with the trial court, which was refused to admit the evidence, a document in evidence. Pleading agreed the evidence hearing preferred supervision, which was dismissed, and the appeal by suggestion. Having heard the learned counsel for the party, we are satisfied that the order dated so and so passed by the trial court, holding that the agreement dated is inadmissible in evidence for want of registration cannot be sustained and has to be set aside. A perusal of the document reveals that so and so the executed in one of the four brothers is purchased the property so and so prior to so and so. The document recites that the land was purchased by four brothers jointly, though the sale was executed only in the name of executed. The document further goes on to record that in order to confer title on all the brothers, the executed would execute sale deed in favor of the brothers, the concession having been received ordinarily in equal shares from the brothers when the property was purchased years before. Such a document does not fall within the category of any of the documents listed under clauses A to E of subsection 1 of section 17 of the Registration Act. No title is created, declared, assigned, limited, or extinguished, whether in present or in future, by the said document dated so and so. The document merely contains a recital to pre-existing title and also promise to execute sale deeds in future so as to confer title by such sale deed which are yet to be executed consistently with the share of the brothers in this property. The trial court clearly erred in holding that the document to be compulsorily restated. The refusal of the trial court to admit the document in evidence has occasioned a failure of justice and that.
You see, this particular two things are important. Firstly, it is pre-amendment. The agreement was of the year 1991.
Yes.
That was prior to 2000.
That is even
Now see the nature of the document. Whether this particular document, by which you say that the relationship of landlord and tenant has ceased, does it have the impact of limiting, assigning?
no, it is only an agreement because this agreement, until and unless it is enforced by a suit for specific performance, that decree, I would not have a right to claim only on the basis of that. I cannot title. Title would not come into me and extinguish the title of the land. original land. Only after the sale is executed, then only there would be limitation or extinguishment of title of the original land.
And still such is done,
Yes.
you remain a tenant.
No, not because this is the reason. First, Your Lordship, we must whether this document is compulsorily registrable. This is the first thing I have to show. According to me, because it is not limiting or extinguishing any right of the original owner, and the original owner still remains the owner of the property till actually sale deed is executed. We cannot say that I am the owner of the property only on the basis of the agreement. So till that is active, therefore, if none of the conditions of section 17 is being fulfilled, this document was not compulsorily registered. My first submission would be. Second would be, now what would be if the document was not compulsorily registered, then what would be the consequence? The consequence would be that the document has to be taken into evidence, it has to be read in evidence, which the courts below have failed totally ignored for separate reasons, but the courts have.
So you want to say the landlord-tenant relationship continued, but the liability to pay rent did not continue.
No.
By virtue of
No. Because
Then what is your status?
my status is that I am a purchaser of the.
So your status for the landlord changes according to you.
Changed as purchaser and not as a tenant.
That's right.
Yes.
Change as so this particular document has got the impact of changing your status.
Changing my case, but it is whether.
And this particular document is the subject matter of consideration by the Honorable Supreme Court. You
Yes.
just have a look at the content of the document.
Yes. It was.
By the same document dated 7/12/1991, the document merely contains a recital as to the pre-existing title and also a promise to execute sale deeds.
Yes, this is
So
important.
there is a pre-existing title for the purchaser.
Yes.
You don't have a pre-existing.
No, I do not have.
Then
But here it is in two portions. Here it is that it was acknowledging a pre-existing title of the. Then also the Honorable Court said that it is not a compulsorily registrable document. Here this actually goes in my favor. That was a document which was acknowledging that you have a pre-existing title over the property. Then also the Honorable Court said that that is not a document which is compulsory registered. And second portion of the same document is that it acknowledges that I would execute this. This I'll read it once. The document recites that the land was purchased by four brothers, though the sale was executed only in the name of the executant. The document further goes on to report that in order to confer the title on all the brothers, the executant would execute sale deed in favor of the brothers, the concession having been received already in equal share in the property. Such a document does not fall within the category of any of the documents listed under clauses A to B of section 17 of the Registration Act. No title is created, declared, assigned, limited or extinguished, whether in present or in future by the said document dated 7/12/1990. Here I'll pause. Now this line, achievement 90, whether by this agreement, whether the title is created in my favor, it is not. It is only by way of a final sale only the property title would be created. It is the title is not declared in my favor. It is not assigned. There is no assignment. There is only a contract to perform a future at a future date, limited or extinguished. It is not extinguishing the title. So here the first, I'll answer the first question. First thing it has to be seen whether the document was compulsorily registered. Once Your Lordship find that this document was compulsorily registered because it was extinguishing the right of or title of the landowner, then but merely because there is an agreement that by itself the there is no extinguishment of the title of the original. It is only upon
So
performance.
therefore, there is no extinguishing of the title of the original owner. But by virtue of this agreement, your liability to pay rent extinguishes.
No, because
Because
in that
as per
case,
the clause of the agreement,
no,
as per the clause of the agreement,
I'll come to that.
at best you can argue this because there is some change in the status.
Some change,
There
but
is some change in the status. Title is not passed.
title is not passed.
Title is not passed.
I cannot.
But therefore, at best you can argue that though by this agreement the title does not pass,
Yes.
but your liability to pay rent extinguishes.
Extinguish because there is a specific term in the agreement itself that now there are two circumstances.
There is an agreement to pass the title in future.
In future, there are two circumstances. Let us assume, take a case where there is an agreement, there is no landlord-tenant relationship, and there is an agreement to execute a sale in favor. Whether that document is required to be registered, that document is not required to be registered. Now, as the Rochit have earlier also pointed out, only clause is section 53A where the document is required to be registered.
If you want to claim the relief under
Yes,
this,
yes.
if you want to avail that defense.
Yes, yes. So here the first contention is that because there was an agreement to sell and the status of the parties itself changed from landlord tenant to to purchaser and it no longer remained as that of a landlord tenant. It changed to purchaser and the landlord.
And seller.
And seller. Purchaser and seller. So the moment that changed pursuant to the agreement, then his suit under BBC Act would not be.
'This is by virtue of the clause in the agreement.
Yes. This acknowledgement was there for the reason that this acknowledgement. It is accepted and affirmed herewith. It will make clear that after September 2007, the monthly rent of the said premises shall not be chargeable from the second party as advance amount for total cost premises which has been received by the first party. The second party has been. So here the landowner is acknowledging me that my status from tenant it has changed to a purchaser, prospective purchaser.
Is there any compulsion in law that there has to be a rent?
There has to be.
Can there be a landlord-tenant relationship without rent? Zero rent.
Because it says that to the 11D, section 11. Section 11.
11B.
Yes, 11.
Rent has been defined.
No.
Rent has not been defined.
Fair rent has been defined.
And rent as such has not been defined.
No. Only fair rent has been defined as fixed by suit. But section 11 would be there. What it says, D, 11D. The amount of 2 months' rent lawfully payable by the tenant and due from him is in areas by not having been paid within the time fixed by the contract. So if there can be a contract where it says that you are not required to pay rent. So
There can be a contract.
yes, and there
And
can
still
be.
there can be an eviction suit on ground of subletting or whatever.
Because what would default do? Default would create a right in favor of the landlord to seek eviction. So it is for the landlord, he can pay also. There is no law that merely because I have defaulted, there would be an automatic case would be instituted and I would be evicted from premise.
That is why I am asking this question.
Yes,
Because there is admittedly no agreement of rent.
yes.
There is no agreement of rent
Agreement?
between the parties of rent. Deed, there is no rent deed,
No.
right? There is no rent deed as such. Relationship of landlord-tenant stands admitted. There is a dispute regarding quantum of rent. Now an agreement crops up which says that in future or from a particular date no rent would be payable, whatever be the reason. Maybe changing the status as per seller purchaser, or there could be many other reasons that the landlord says, okay, don't pay me the rent and you remain in the property. Because there could be a situation,
Yeah.
landlord is away
Absolutely.
and he wants some kind of maintenance that somebody has to maintain the property. There could be many reasons as to in such circumstances where suppose you have a property in remote village and there is nobody to stay. You can ask somebody that yes, you remain here as a tenant or whatever, but don't pay me rent. You just enjoy the property. I do not know whether such an abstract is possible under law. Now an agreement comes into picture which says that from this particular date no rent is paid. Then your contention is the status will change as seller and purchaser because of other clauses of the agreement. Right?
Yes.
Because of other clauses of the agreement. But at the same time, can it be said that the landlord agreed not to accept rent beyond a particular period?
Absolutely, this would always be there. Because once he enters into an agreement and says that you are not required to pay rent, then the law does not say that no, you have to
And
disperse.
this is irrespective of specific performance of contract. At best.
Yes.
Because specific performance of contract would be, suppose it happens that the specific performance of the suit is dismissed. The specific performance suit is dismissed. Let us assume for a moment that your suit is dismissed.
Absolutely.
Then under such circumstances, even if there can be a dismissal of suit on many reasons, it is time barred or whatever, there could be a situation that in the specific performance contract the agreement is established, but there may be number of reasons, not billing and performing, and there are so many reasons. Then under such circumstances the status will not revive as per Act. As per the judgment of Supreme Court, the status of landlord-tenant will not revive.
No, it would be
Then
there.
they will be entitled to seek recovery of possession.
Yes, but
And if the document is unregistered, then you will not be able to seek your relief under 53.
yes, in that suit where they file a recovery claiming me to be a person who has entered into possession, who has taken possession and that document is unregistered, and therefore in that recovery of possession suit, I cannot take shelter of section 53 on the ground that because it is an unregistered.
Rent agreement as such is not compulsorily registerable, is
No,
it?
what it is, if it is, that is there in section 17. There are two types of tenancy. One is month to month. Then if it is month to month, then obviously that is not required to be registered. What is required to be registered is there in section 17 itself, section 17D.
Yearly rent.
Lease of immovable property from year to year or for any term exceeding 1 year or reserving it. So if it is any lease which is beyond 1 year, then it has to be registered. So if there is a lease between us where I lease out a property to him for a period over exceeding 1 year, then that document has to be registered. But there are judgments of courts that even if that document is not registered, then in terms of that for the collateral purpose, because now that would be a document which is compulsorily registrable under section 17D, then and it is if it is not registered, then and in terms of section 49, it can be seen only for the collateral.
What about the second judgment?
This is the main judgment 2009 SCC, page 339.
You are relying upon this Girish Chandra Datta.
First, before placing this judgment, again agreement that clause may be seen and then I'll place it. I say that this judgment is very covered. Agreement dated 30/10/2008. Second page. Third page. Total cost of rupees being subsequently paid so and so only as advance by the second party to the first party in cash, and the said amount has been received by the first party from Ajit Kumar Sinha. It is accepted and affirmed herewith. It is made clear that after September 2007, the monthly rent of the said premises shall not be chargeable from the second party as advance amount. This is the reason that he is saying that no rent would be chargeable. As advance amount, again the total cost of premises with house and pictures have been received by the person. That means because now there is an agreement to sell and he has already complied and paid the advance amount, he is not required to pay the concession monthly. So acknowledging me to be a prospective purchaser. Now this judgment. My learned friend rightly pointed out two definitions. One is landlord and tenant. In that also it says landlord includes the person for the time being is receiving or entitled to receive. So by that agreement, the landlord himself, because of the subsequent agreement as prospective purchaser, acknowledging that fact, he says that rent is not required to be. Include a person from the time he is receiving or entitled to receive the rent of the building, so and so. And same is with the tenant also. Now this judgment. relevant portions, can I read para 2 of
The
last?
facts are, you see, I've read this judgment many times.
So,
So facts are
I'll,
clear to me.
I'll only
There
rely
was
on
a
para
specific clause in the agreement also, which I
Yeah.
have distinguished in my judgment also. I just placed it there. That they surrender the property and surrender your possession, that which is in italics in para number 4.
Yes, that I have seen. Your Lordship said already. And then the another judgment also which has been quoted in para 7 is
Yes.
we are of the view that old relationship of landlord tenant came to an end, the rights of liability have to be worked out on the basis of the agreement. And para 6 and 6 to 8 have been denied. So my concluding submission would be that based on the agreement, my status from tenant changed that to a prospective purchaser, and then therefore a suit under BBC Act was not. Once the suit was not maintainable, everything else was. Suit has to be dismissed. Then, if suit is not maintainable, then there's no question of going into other. If another suit is filed for recovery, then the rights of the parties would be there on the basis of the already instituted suit, or in that suit if they file a counter claim for recovery. A normal suit. Rent controller, the court
What is the
crime.
effect of these documents being marked with objection?
Yes. The effect would be that even if this document has been marked with objection, then the courts below, both the courts, have not even discarded this. They have in fact relied on, they have in fact said that this document is there, but for some other reason I am not like that. Both courts have not gone into this. Whether it was there was any such agreement or not. The validity of the agreement has not been.
Only reason for not relying upon this document
Is unreasonable.
appellate court is that it is an unreasonable.
Unreasonable, that is. And the trial court is that
It's completely
because
silent.
there is already a landlord-tenant relationship which I admit, therefore despite the agreement, I continue to be agreed. Which again I say would be directly against the
He has also given you number of judgments. Do you have to say anything on that? You can say right now because the judgments are already there.
Okay.
You can distinguish if you want to.
My learned friend has relied on two judgments which he had yesterday placed. One was 3 SCC online, one was 2003 SCC online. Shape Solar.
एक के बाद एक सारे जजमेंट्स हैं।
हाँ,
सबसे पहले 1999 सीक्वेंस में बताइए।
1999 is the
वॉल्यूम 2 की है ऑनरेबल जस्टिस डेट। It says that merely because suit for specific performance is pending, the same has no bearing.
this again 1999 and both by in 2003 judgment. In both these, the earlier judgment of the Honorable Supreme Court was not there when this first judgment of 1999 was being passed. It was subsequent. Therefore, in view of the law laid down by Honorable Supreme Court in 2009 SCC, this 1999 judgment cannot be seen.
एक सेकंड। While distinguishing the judgment reported in 1999 with bracket 2 bracket case PAGR 189, the learned counsel for the appellant has submitted that the judgment passed by Honorable Supreme Court, reported in bracket 2009 bracket close, SCC 339 was not available for consideration at that point of time. And further, ये तो साइट ही नहीं हुआ 73 वाला.
उस समय
73 वाला तो अवेलेबल था, साइट तो नहीं हुआ.
कौन वाला
73 वाला तो 2000 में 73.
2003 वाला
2009 में 73 वाला जजमेंट कंसिडर किया है गिरीश चंद्र दत्ता. पैरा 7
ऑनरेबल जस्टिस मराठिया वाला
आप 2000 का जजमेंट निकालिए. गिरीश चंद्र दत्ता जो कंसिडर किया पैरा 7 में, that was not cited.
हाँ that was yes
इसमें भी तो ये बोला है ना
हाँ
that the rights and liabilities of the parties has to be worked out on the basis of the agreement.
I understand. This was available.
This was
Although
available,
2000 was not available, but
The
this
learned
was.
counsel has also submitted that the judgment relied upon by the Honorable Supreme Court in the judgment reported in bracket 2009 SCC 339, that is judgment passed in the case of Arjunlal Bhattmal Gothani versus Girish Chandra Datta, reported in bracket 1973 bracket close to SCC 197, was not placed before the court.
It would be better that I am relying on Arjunlal Bhatt also.
Yes, it is there. We are of the opinion that when the agreement dated was entered into old relationship of landlord and tenant came to an end.
Okay.
इसमें ये
हाँ.
है ये observation. He will distinguish it. This is one thing. Next.
Second is 2003 Sheikh Sohra.
उसके पहले इसमें आएंगे. हम सीक्वेंस में चल रहे हैं.
अच्छा.
ये वाला बताइए. ये 2000 अच्छा 2003 6 हो रहा.
Sheikh Sohra. Now, by that, this time, we are both the 2000 volume 9 SCC and the 1973 judgment, both the Honorable Supreme Court judgment was not brought to the notice of the Honorable Court, and then this particular judgment was not passed.
ये 6 वाला आपका पहला पेज नहीं दिया है क्या?
एक पेज नंबर बैक से सिर्फ तो फाइल है
2003 वॉल्यूम 1 JLR पेज
हाँ,
नंबर
ये
कितना है?
भी एक कॉपी है.
हाँ, देखिए तो.
सही.
With respect to the judgment reported in 2003 within bracket 1 JLJR page number 591, right? Sheikh Sohra versus Mohammed Qasim Ansari, the learned counsel has submitted that in this case also the aforesaid two judgments of the Honorable Supreme Court have not been cited.
The judgment of 1973 and the judgment of 2009 were not.
Both the aforesaid judgments were under revisional jurisdiction. Revision में आया.
हाँ, दोनों revision.
आगे बताइए.
1999 में तो 2000 वाला नहीं हो सकता.
हाँ वो तो हो ही नहीं सकता, वो लिख लीजिए.
उससे 73
लेकिन इसमें दोनों जजमेंट की साइड भी.
हाँ दोनों. अब now there is another judgment, Srimati Manju Devi, ये भी Munmun Banerjee versus Srimati Manju Devi, 2009 volume 3 JL.
with respect to the judgment reported in bracket 2009 volume 3 JLJR 19, page 19 है ना? Page 19. क्योंकि next page to 20 है तो 19 है. 19. The learned counsel has submitted that the judgment of Sheikh Sorab has been relied upon in the same judgment. ये कांतिमती भी तो रिलाई है.
हाँ काफी, लेकिन इसमें बहुत बड़ा डिस्टिंग्विशिंग फैक्टर है.
हाँ. And the judgment passed in the case reported in bracket 2000 within bracket volume 9 SCC 339 Kantimati has been considered but has been distinguished on facts. और बताइए.
First it was that it was only for 11 months. It further appears it is in internal.
Agreement had expired. So the agreement had expired. In as much as the period of agreement itself had expired.
But there is one more very important line I'll point out subsequently.
And the agreement had become unenforceable. Unenforceable. Even the judgment passed by the Honorable Supreme Court reported in bracket 2002 bracket close 3 SCC 676 has been distinguished in the same judgment. इसको भी distinguish किया, दोनों को distinguish किया. वो 53A से related था और ये वाला था relationship of landlord.
लेकिन एक लाइन हम वो एकदम बहुत इम्पोर्टेंट लाइन है, बहुत बड़ा डिस्टिंग्विशिंग, वो हम प्लेस करते हैं पूरा.
बताइए. कोई बात नहीं, तब तक ये देख लेंगे. और बताइए. सूरज लैंड्स.
Your Lordship have already in another judgment, although it was in the facts of that case it was said that there was no change because that agreement itself mentioned that she would continue to make payment. Here my case would be that because the agreement itself said that in view of the advance payment which have been made, my status changed to that being a tenant to
The learned counsel has also referred to the judgment passed by this court in essay number 80 of 2011, decided on 26/2025, and has submitted that though in the facts of the same case there was a clear stipulation that the tenant would continue to pay rent, and therefore this court has held that there was a continuation of relationship of landlord and tenant between the parties. But in the present case, there was a clear stipulation in the agreement that the tenant would discontinue to pay rent, And therefore, on this distinguishing fact and on the principles of law, the case would be covered by second appeal number 80 of 2000 on the point of relationship of landlord and tenant between the parties.
Seized.
On the point of seizure of relationship of landlord and
Yes.
tenant between the parties, which was decided under substantial question of law number B in the same case. Correct. और बताइए सूरज लैंड्स में क्या बोलना है आपको? You cannot dispute Suraj lands. Agreement of sale से कुछ नहीं होता.
सूरज लैंड से हम तो बोल रहे हैं, I do not become the owner of the property.
With respect to the judgment reported in bracket 2012 bracket close 1 SCC 656, he has referred to paragraph 19 of the said judgment to submit that there is no dispute that according to Transfer of Property Act, an agreement of sale, whether with or without possession, is not a conveyance.
Not, yes.
He submits that accordingly, the agreement itself was not compulsorily registered.
Yes.
Next judgment. ये अश्विनी पॉल 2018 4 SCC.
Now 1914 also very much.
2019
19 probably years July.
नहीं एक है 2018 4 JCR JHR.
Party's name is
Party name is Ashwini Kumar Paul versus Kamta Prashad. There these judgments have been cited.
I'll reply to this in rejoinder. In the meantime, we will please.
Yes. Only one of the on facts it is distinguishable. Anyways,
we
you will
have-
distinguish on
Fact हम कर देंगे.
update.
Even
You
other
will
ways.
respond when he.
Even other ways.
और बताइए ये वाला
Let us-
2022 वॉल्यूम 13 SCC 756 इसमें क्या बोलना है? ये आप किस लिए डिलाई किए हैं? 2022 13 SCC 756. On what point? Para 11 kilo.
This agreement to sell is not will not convey title.
No, I do not dispute this.
There is
proposition.
there is no doubt on that.
And now with respect to this, here in this case, there was an agreement, landlord tenant relationship was admitted, and the parties will not.
Anyways, you will have your turn to place this judgment. You distinguish this also.
Let me will not complete making, then you will distinguish.
Okay, fine. That would be good.
Yes.
इनका सबमिशन लिखा है?
हाँ.
The learned counsel for the appellant referred to the claimed and the written statement. while referring to the plaint, he submits that the plaintiff claimed to be the owner and landlady of the property and asserted that the defendant was a tenant at monthly rent of rupees 15,000 per month. It is also admitted that it has also been stated that the defendant was inducted as tenant by her husband, who expired on 10th of March 2009. The further case of the plaintiff was that the defendant was a habitual defaulter in payment of rent and he had paid rent only up to December 2003. And in spite of request, he did not tender rent. However, after the death of her husband, the plaintiff sent a legal notice dated 23/10/2009. The plaintiff in para 9 claimed that the defendant rendered himself liable for eviction for non-payment of rent since January 2004. He has then referred to the written statement and has submitted that the defendant had specifically denied the relationship of landlord and tenant and has asserted that the suit itself was not maintainable. However, the defendant had clearly stated that the defendant was inducted as a monthly tenant with respect to the suit premises by the husband of the plaintiff since 15 December 2001, but the rent was only rupees 3,500 per month. The husband of the plaintiff entered into negotiation with respect to the sale of the property to the plaintiff, to the defendant, and the consideration was fixed at rupees 35 lakhs, and a memorandum of understanding was executed on 3rd of November 2007, by virtue of which the husband of the plaintiff undertook to sell the property for the said consideration, and an advance of rupees 1 lakh was paid through check. And as per the memorandum of agreement, upon encashment of check, an agreement for sale was to be executed. Consequently, the check was encashed and the agreement of sale was executed on 30/10/2008. By referring to the earlier memorandum of agreement dated 3/9/2007, and the sale deed was to be executed on or before 3/9/2010 after receipt of the balance consideration amount of rupees 30 lakhs. But prior to reaching such date, the husband of the plaintiff had expired. It was asserted in the written statement that the defendant was not required to pay rent to the plaintiff, and it was also asserted that the plaintiff was in possession of the property in part performance of the agreement. It was further case of the defendant that the defendant was still ready and willing to pay the balance consideration amount and ultimately a title suit was filed seeking specific performance of contract numbered as title suit number 474 of 2009. As per the written statement in paragraph 8, it was stated that as per the terms and conditions mentioned in the agreement dated 30/10/2008, the husband of the plaintiff acknowledged receipt of ₹1 lakh only as advance under memorandum of understanding dated 3/9/2007 and received further advance of ₹3 lakhs from the defendant. And by virtue of the said agreement, the defendant was not required to pay rent of the suit premises to the husband of the defendant, to the husband of the plaintiff. And it was stated that the relationship never existed as landlord and tenant between the landlady and the defendant. Yeah. The learned counsel has then referred to both the agreements, both the memorandum of agreement and the agreement of sale, which were marked as Exhibit A and E respectively, but with objection. He has referred to the terms and clauses of the memorandum of agreement, of the agreement of the year 2008, and has in particular referred to the following clause. ये जो आपका पेज नंबर 2 से यहाँ से कोट कर देते हैं, बॉटम से, whereas as per memorandum of agreement, आप चेक कर लीजिए, इसको यहीं से कोट करेंगे, whereas as per the MOU dated such and such. पेज 2 से, ठीक है?
Particularly page 3 का.
हाँ, पेज 3 का it is made clear. हाँ, वो पूरा ही कोट करेंगे.
ठीक.
और उसका clause 1 भी कोट करेंगे.
Clause 1 of your lordship is reading MOU or?
नहीं, I am reading the agreement.
Agreement, yes.
हाँ.
Whereas page 2 में तो है. Page 2 और continues to page 3, that is the most important.
हाँ, that I have recorded. Six is also important, that if you do not sell it, then you will be entitled to pay rent at the rate of 1000 from October 2000.
And all these have not been considered by court.
यहाँ से लेंगे ना, इंटरनल पेज 2 से लेकर 3 to 4 तक कोट करेंगे इसको, ठीक है? The learned counsel then referred to the judgment passed by the learned
There are
tribunal.
4 also of the same, that the second party shall have no right to transfer or make any type of.
वो सारे ही कोट करते हैं,
हाँ, ठीक.
वही तो important है.
हाँ.
The learned counsel then referred to the judgment passed by the learned trial court and has submitted that the issue number 3, 4, 6 and 7 are relevant for the purposes of the adjudication of the substantial question of law involved in this case. He has submitted that issue number 3, 4 and 5 were taken up together, and after quoting the provision of the BBC Act, the learned court recorded as under internal page 12 में इतना quote करेंगे तो mark किए. He then submits that thereafter further section of the Act was quoted and the findings have been recorded at internal page 14 as under 14 and 15 का issue number 6 and 7 तक का finding note कर देंगे. The learned counsel, while referring to the trial court's judgment, has submitted that the trial court has not at all considered, has not at all decided the issue number 7 as to whether the agreement, whether after the agreement the defendant was not required to pay rent of the premises to Satyendra Kumar Sinha, the husband of the plaintiff. He has submitted that the learned court has also not considered the impact of the MOU and the agreement of sale. While referring to the judgment passed by the learned first appellate court, the learned counsel has submitted that the points for determination have been, the point for determination has been made in paragraph 10, which is as follows, quote, whether in view of alleged unregistered agreement to sale in favor of the appellant, there subsists any relationship of landlord and tenant between the respondent and the appellant, inverted comma close. The learned counsel has submitted that the learned first appellate court has recorded a finding that there was a relationship of landlord and tenant between the parties, but has refused to consider the agreement, Exhibit E, by referring to section 49 and 17 of the Registration Act, by holding that the same is inadmissible in evidence, and consequently the impact of agreement entered into between the parties has not been considered at all. He submits that the defendant had placed reliance upon the judgment passed by the Honorable Supreme Court reported in bracket 2000 9 SCC 339, and has asserted that in view of the same judgment there was no relationship of landlord and tenant between the parties, and therefore the suit for eviction under the JBC Act was not at all maintainable. But since the agreement was held to be not admissible in evidence, the impact of the agreement has not been considered. The learned counsel has submitted that the learned first appellate court, the learned first appellate court has completely misdirected himself by considering section 49, section 17, 49 of the Registration Act, and also section and also section 53 capital A of the Transfer of Property Act. The learned counsel submits that on the basis of the agreement, it was to be examined as to whether there was any relationship of landlord and tenant between the parties post the agreement, particularly in the light of the aforesaid clause that by virtue of the agreement the defendant was not required to pay rent, and in case the agreement does not culminate into sale, then the reason for payment of rent from October 2007 was stipulated in the agreement itself. He has submitted that had the agreement been considered in the light of the judgment which was relied upon by the defendant before the learned first appellate court, there would have been no difficulty in holding that the relationship of landlord and tenant between the parties had ceased.
ceased, and therefore consequently no suit was made.
And consequently the suit under the BBC Act itself was not maintained. He has further submitted that had the plaintiff filed a suit for recovery of possession by claiming title, then the defendant would not be in a position to claim the protection of Section 53 capital A of Transfer of Property Act, as admittedly the agreement was unregistered. Okay?
And the basis of the suit itself filed by the plaintiff is essentially a landlord tenant relationship. If that was not existing, the
The
suit
learned
itself
counsel
was
submits that the basis of filing a suit under the special act was the relationship of landlord and tenant between the parties. And by deciding the relationship of landlord and tenant between the parties, the agreement has been completely overlooked
yes,
on the erroneous application of it.
yes,
That's it?
yes.
Appetite.
One major difference which I was facing was 2009 volume 3.
अभी बात में
नहीं अब वो उसमें फैक्ट में होल्ड किया गया था देयर वाज
नहीं बाद में उनके रिस्पांस को बोलेंगे उनको अपना जजमेंट प्लेस करने देंगे साइमल्टेनियसली आई विल परमिट यू टू डिस्टिंग्विश देयर इज नो प्रॉब्लम अब उनको सुनते हैं यस
last submission was that both the courts have not, although it was marked with objection, but they have not disbelieved the error.
The learned counsel has submitted that though both the memorandum of agreement, memorandum of understanding and the agreement were marked with objection, but both the courts have not disbelieved the same.
Yes, and rather they have only disbelieved on the ground that whatever the constitution apart.
But the same has been not considered on technical grounds
Yes.
that it was the agreement was an unregistered.
So far as facts are concerned, not sure whether there was facts or not. Just for repetition, 2-3 paragraphs of the written statement I would like to listen. So page number 3 of the written statement.
Page number 3.
Paragraph number 6, Roman 1. Roman 1.
Page number 3, para number
6. 6 number
7 का 1. 7 का 1.
Oh, I'm sorry, 7.
7 का.
Not, it says without the defendant was inducted as a month-to-month period with respect to the building premises. Not, there was no rent agreement, they were equal month-to-month period. Not, Romans page number 6, Roman 5.
Yes.
By virtue of this said agreement, the defendant was not required to pay rent of the suit premises to so and so, and the defendant is continuing in possession in part performance of the said agreement to sell, and the right of the defendant continue in possession of the premises in part performance of the agreement. You have similar statement page number 10 again, and this is the admitted case also. Now, it will come to how the appellate court judgment was.
Yes.
I'm sorry.
The learned counsel for the respondent, by referring to the written statement, has referred to para number 7 within bracket Roman 1, 7 within bracket Roman 5, and para number 8,
Para number 8, page number 10.
page number 10.
Yes. And we are
Relevant at page number 10.
page number 12 also for last line. Defendant is continuing in possession of suit premises the part performance of agreement to sell and is not required to pay rent of the premises.
And has submitted that the relationship of landlord and tenant is to be admitted. Inasmuch as the plaintiff, the defendant admitted that he was inducted as tenant in the suit premises. And it was the specific case of the defendant that they were in possession of the suit premises in part performance of agreement, and therefore they were not required to pay rent. यही आपका यही सबमिशन करना चाहते हैं? That's it.
Now I am referring to the appellate court judgment. Since the facts are more or less has been placed, but not having selectively, I am just answering.
Yes, ma'am.
But page number 9 of the internal page 9 of the appellate court judgment.
Yes.
Not only the last line, very last line. It is further been argued that the alleged agreement to sell,
Sorry, internal page
internal page 9,
9, para number
your para number 9,
9.
last line, bottom line.
Okay, it has further
It is further been argued, as was that the alleged agreement to sell, exhibit E, has been a manufactured and moreover the said document, being an unregistered document, has no evidence regarding. Not the substantive question of point determination has been quoted. Thereafter, we have PW1. When reading the middle portion, witnesses further say, as much as middle portion. PW1.
Yes.
The witnesses further says that it is wrong to say that the husband of the plaintiff had entered into agreement to sell of the house and received rupees 1 lakh through a check and 4 lakhs in cash, total 5 lakhs from the defendant. Witnesses claim that any agreement to sell with the defendant, with the husband of the plaintiff is forged, the agreement is forged. The agreement is forged. What PW2? From last 5 months in para 101. Does it also brought up? PW2,
PW2.
जो नीचे से है 5th line. In
Page.
page number internal page 111.
11.
Yes. And in bottom 5th line. In para 101 of his cross examination, to the suggestion that after the MOU the defendant had paid the witnesses rupees 1 lakh by check from the out of consideration rupees consideration money of 35 lakhs. The witnesses answered that the rent from June 2003 to December 2003, defendant had given a check of rupees 1 lakh and assured to give 5,000 which he did not pay. Not that 1 lakh was for the rent for period of 2003 to December 2003. Which
From
comes
June 2003.
yes, to the December 2003, which comes to 1 lakh 5,000, and this 1 lakh was adjusted and 5,000 remaining was to be paid subsequently.
You didn't claim any agents of rent. So according to you, the rent was how much?
15,000. You have to recalculate 15,000 into the remaining, which comes to 1 lakh
But there is no
5,000.
finding. There is no finding as to what
Yes,
was
there is no
the
finding.
There is no finding.
But this I'm showing this is the deposition mirror. Then they say so far as the agreement is concerned, this witness also said it's the denied of the existence of this agreement. And then PW3, page number 12, the very last line, the witness claims the alleged agreement is forged.
Detail.
First paragraph, PW3, in order to show just first paragraph I know. To the top.
Witness claims that they will disposed. The agreement is forged. What about the MOU?
Both.
Which is referring only to the agreement is forged.
No, this deposition is being partly recovered, deposition is not permanent, I can give you this. Just to cut short, I just mentioned from here.
But there is no finding that.
That is true, there is no finding, but I am just showing that we are disputing the existence of the MOU as well as the agreement. Now, can you take your page number 16 of the judgment, number 16. Please, number 16. The Learned Counsel of hearing on behalf of the respondent has put his reliance on the judgment of so and so, wherein it has been held by the Honorable Patna High Court that any document containing contract to transfer for consideration any immovable property for delivering the benefit under Section 53A of the Transfer of Property Act must be registered.
There is no doubt. There is no doubt on this. 53A जहाँ claim करेंगे post 2001 it has to be registered. नहीं claim कर रहे हैं under landlord tenant relationship under special law, right? You are claiming, but it is under landlord tenant relationship, not on ground of title, but on ground of landlord tenant relationship, default in payment of rent and on personal.
Suppose this agreement is not registered, how can we consider it? But if suppose this agreement is not registered in view of Section 17(1)(a).
So that yes, argued that you will have to
Yes,
answer.
sir, that's why we are saying Lord that it was
53A cannot be 53A cannot be considered.
They are claiming about the specific statement, the written statement, the part performance of that agreement.
That plea is outright rejected. The point is whether the landlord-tenant relationship continues. That is the point.
Then we have the first substantial question of law, Lord, which is formulated exactly this. 53A has been taken, Lord. Lord should see this first substantial question of law, Lord, which says whether the first appellate court, while affirming the judgment, was justified in refusing to consider Exhibit E on the ground that it was unregistered document. Lord, since it was an unregistered document and they were claiming on the basis of hard performance, therefore the court has rightly
Do you want to
rejected it.
say that all the agreements are to be compulsorily registered?
In my humble submission, yes, Lord. Say when except Lord, if there is a case subsequent for specific performance, and it can be ignored or for any collateral purpose.
So, for if there is a suit for specific performance, that agreement is valid.
For specific performance, yes.
Yes, for specific performance it is valid. And if a person is resisting dispossession, right? Then under such circumstances, 53A will not be available to him.
So,
53A will not be available to him by claiming that he has become an owner of the property.
yes.
Because 53A says that you acquire the your dispossession is protected by virtue of the fact that you are in possession of the property by virtue of a registered agreement of sale.
Yes.
So are they claiming the property by virtue of being the owner of the property?
No, as a prospective purchaser, they are.
As a prospective purchase.
Yes.
So they are not claiming the property as an owner of
And
the
what
property.
is the status now? What is the status? My question to myself, my lord, I am the owner, admittedly I am the owner of the property. And suppose lordship put a question that suppose specific performance suit get dismissed for whatsoever may be the reason. I am putting this taking suggestion to make more further. Lord, this suppose this eviction suit is dismissed. On the ground, my lord, pursuant to the coming into force of this agreement, alleged agreement, my status as landlord tenant failed. I am not a landlord. And thereafter, my lord, that suspension for suit is also dismissed for any reason. My lord, what would be my status, my lord?
Your status would be you will claim
Therefore, my lord,
you will claim recovery of
again, my
possession.
lord, a suit.
Certainly
Again,
a
a
suit.
suit. Yes.
Certainly
Therefore,
a
my
suit.
lord, therefore,
You
my
will claim recovery of possession by claiming that by claiming title of this. You have to claim title coupled with recovery of possession.
Lord, then my lord, the suit, appeal, second appeal, whatever the fate, my lord, it will go thereafter. I will file a suit for recovery of possession after.
We do not know
Yes.
what stage
No,
you will
Lord.
file.
Yes, that Lord, now my
Or
lord.
you may not be required to file. We do not know. You may win also.
My lord, now the question is, Lord, now if Lord this suit is dismissed, suit is dismissed, suppose Lord this eviction suit is allowed, or eviction suit is allowed, decreed and second appeal is dismissed, they have a remedy, Lord, a specific performance to get it executed. They can, if they succeed there, Lord, they can
There's
benefit get the
no
property.
doubt on that.
Lord, if I lose, Lord, this case, Lord, then I have nothing to gain, Lord.
No.
Lord, this is the situation which the Lordship would. I just also extended to first little further. Lord, if they win, Lord, they have a remedy to recover the property in view of the deeply past specific. But since Lord, I lose, Lord, here, I will nothing to win, Lord. I will gain nothing. Send an exam litigation. Lord, Lordship put a question, I extended further till further. Lord, I give up to my lords to consider it. Lord, in my humble submission, let me kindly complete Lord this paragraph also. In my humble submission, section 53A comes into place because they are claiming possession on the basis of 53A. I will satisfy my lords that they are claiming 53 on the basis of the possession pursuant to this agreement. Therefore, it is required registration. I will satisfy my lord. I will try to satisfy. I'm sorry. Lord, I was reading, Lord, any document containing contract to transfer on for consideration any immovable property for deriving the benefit under section 53A of the Transfer Property Act must be registered if it has been executed after the commencement of the Amending Act 2001. And in case such document is not registered on or after the commencement, it will have no effect for the purpose of invoking the doctrine of part performance under section 53A. The doctrine of part performance protects the rights of the transferee of an agreement for sale. If he has been put in possession or continues in possession in part performance of contract or has done some act in furtherance of contract. Prior to the Amending Act 2001, a party could claim benefit of such possession on the basis of doctrine of part performance, even if the agreement for sale was not registered, but the same has now been specifically barred by the Amending Act. Number 17.
No,
Here-
you are kindly pause here for a moment. Does it say that all the agreement of sale are compulsorily registered?
If it is sued for specific performance, it is not. But Lord,
Does it say that, you see, specific instance has been given that for suit for specific performance, the agreement need not be compulsorily registered. But does it say that apart from that, all the agreements are to be compulsorily registered?
that is not. I mean, if you not to have it, I can read section 1A again, number 17 1A. The documents containing contract to transfer, which is general term, contract to transfer for consideration any immovable property for the purpose of section 53A of the Transfer of Property Act shall be registered.
So 53A has been inserted with a purpose. You cannot ignore 53A to say that all the agreement are
If
compulsory.
the possession has been transferred, they claim, if the possession has been transferred, then it is required to immediately registered. If
The point is, the question of 53A will come only if they are seeking to retain the possession
on the basis of
53A.
Yes.
But that is not the only reason. In the written statement, they take both the points. They take the point of 53A and they also take the term of the agreement which says that no rent is payable.
yes, I will note that.
Yes.
And now, Lord, as at this stage, I am with respect to 53A, I am arguing as 53A that Since they are taking a plea of 53A, then the part performance of the agreement, not the part performance of the contract, they come into the possession of the property. Then, if this is the situation, then it requires compulsory registration. I will come to second part.
They will not dispute it,
Yes.
and there is no doubt on this.
No.
That
That's
no
what I
protection
want.
can be granted to them by referring to section.
That's all.
There is no doubt on that.
I will try to satisfy with respect to the contents of the agreement or basis of which they are claiming. I just wanted to satisfy it, and since they are claiming, one of the plea was that under 50 in part of our they are claiming possession. Therefore, it requires registration. 53. My only submission is this. Now we are para number 70. The applicant also dealt with in this kind of context also only. The applicant para number 17. The applicant has disputed the landlord and tenant relationship between the husband of the different respondent and himself on the strength of an unregistered agreement to sale. However, a sale agreement is compulsory registrable, required to be registered, and if the same is not registered, then as per section 49 of the Registration Act, it cannot be received as an evidence for any transaction affecting such property conferring such power, though it may be received as an evidence in contract useful for specific performance under Chapter 2 of the Specific Legal Act. In the above position of unregistered agreement, Exhibit B cannot be read in evidence in the present proceeding. Accordingly, in the absence of evidence, the relationship of respondent and the applicant remain as a landlord and tenant. In the above view, the matter issue of genuine so and so not active.
So it talks about, it says that it doesn't refer to 53A. It says that all the agreements are to be registered. This is what para 17 has said.
Yes, Lord.
That all the agreements are to be compulsorily registered except when it is used for the purposes of specific
Yes.
purposes.
But Lord, the law is Lord that if they claim their possession has been transferred, then it requires compulsory registration. And if they take the shelter of section 53A, then it comes section 17 1 capital comes into play. Lord, this is my only submission, which is the finding. Now, Lord, I would answer Lord the Lordship as the so-called agreement is concerned. Lord, I would like to raise 3 of the Transfer of Property Act. But they are not disputing it, Lord, and Lord, because Lord 53 just referring one line. 53, what it says, where any person contracts to transfer for consideration of immovable property in writing signed by him or on his behalf, from which the terms necessary to constitute a transfer can be ascertained with reasonable certainty, and the transferee has in part performance of the contract, has taken possession of the property, or any part thereof, or the transferee being already in possession, continues in possession in part performance of the contract, or has done some act of furtherance. The case is where the tenant, pursuant to this agreement, we continued in possession in part performance. Therefore, 53 comes into play as per their own. Therefore, I was referring to this provision, this finding.
I'm not relying on 53. I'm not relying on 53.
The law is well settled. 53A you cannot claim.
I'm not relying on it. I've
But
said that
yes.
only status and change. That is my whole question. About maintainability of the suit itself. That is my question.
Number, so far as agreement is concerned, which they claim they became a prospective purchaser. In my humble submission, the agreement is also well settled that agreement neither creates nor extinguishes title. I am the owner, and so far as their claim is concerned, they are not the owner. There is no concept of prospective purchaser, because the title can only be transferred by virtue of 5 modes. That is, sale, gift, lease, mortgage, and exchange. These are the only 5 modes of transfer from which the title can be transferred. But this agreement is not a mode of transfer. Therefore, yes, therefore, they are not the owner. They cannot claim ownership on this.
They are not claiming ownership.
Yes,
They are not claiming ownership.
and there is no concept of prospective purchaser also.
There is prospective purchaser is a legal term
Yes.
used in all the transactions of
Unless it
specific
culminates into a
impact.
deed, my lord. Unless it culminates into a deed, my lord, it has no legal status.
Prospective purchaser in case of an unregistered agreement of sale uh, is executable through specific performance.
Yes.
And the transfer takes place only when the deed is executed.
Yes.
They are not claiming title.
Yes.
They are not claiming title at all.
Yes.
They are only claiming that their status is
As a
that of a
prospective
prospective purchaser.
No, who is prospective purchaser? I am going to purchase that property. You are already not the owner.
That's
You are something in abeyance.
We cannot just see this prospective purchaser in isolation.
Yes.
It is a case where the landlord agrees not to take rent and also says that if after some time it does not comes into play, then he is entitled to pay rent, entitled to rent from October 2007.
Lordship
So therefore, I was asking that there is a landlord-tenant relationship. Just tell me one. There was a relationship of 7,000 rupees per month. Is it possible for them to modify the rent to 1,000 rupees? Permissible?
Yes.
Permissible. Okay. Is it permissible for them to defer the payment of rent?
That's no.
Permissible? They can by agreement defer the payment of rent. They can. They enter into an agreement which is specific clause that henceforth no rent is paid. And if this does not fructify into an agreement of sale, because there is a specific date for execution of the sale deed also, then they say that at that point the remaining rent would become paid.
Lord, I would like to clarify one moment. Lord, we are disputing the existence of the MOU as well as the agreement.
That we have noted.
Once we are disputing, Lord, the contents of the document cannot be binding upon me. Because, Lord, my Lord, I would be coming to that later, Lordship. I have left with 53A and now I will be
53A is
Lord,
absolutely no
therefore,
doubt
I
on
will be
that.
coming to the next point, Lord, that is government, Lord. Therefore, I left that point. I will be coming to that, Lord, with respect to this MOU. You are just coming, Lord. Lord, there is a 2025 judgment which I referred to, Lord, we know the infra. That was with respect to the agreement, Lord. If you actually permit, Lord, may I place, Lord?
Yes, please.
Para number 9.
2000 below the income.
Yes. Para number 9, page number 2937.
This para number 9.
Admittedly, the appellant is the owner of the subject property. As stated in the plan, the appellant received rupees 7.5 crores from the respondent number 1 in 2014 through checks in consideration of which unregistered power of attorney and agreement to sell were executed, purportedly based on a broad resolution. Subsequently, those documents were revoked by the appellant on 24/5/2022 and 27/5/2022 respectively. Despite revocation of the fact that the documents were unregistered, respondent number 1 executed a sale deed on 13/7/2022 and 14/7/2022, which were registered on 19/7/2022 in favor in his favor and in favor of respondent number 2 and 4. Pending mark. As per the settled law, the absence of registration, such documents do not confer valid authority to transfer title. Section 17 and 49 of the Registration Act 1908 clearly state that unregistered documents required to be registered are admissible in evidence for the purpose of conveying title or completing a sale transaction and can only be admitted for collateral purposes or in a suit for specific performance. This proposition has been held in so. Lord, I am not to
You read the this quotation also.
Yes. This legal proposition has been well settled in so and so. Section 10, para 10, section 17.
That is quoted.
Quoted words, 49 is quoted. Next one.
Yes, para.
The main provision of section 49 provides that any document which is required to be registered, if not registered, shall not affect any immovable property comprised therein, or any such document shall be received as evidence for any transaction affecting such property. The proviso, however, would show that an unregistered document affecting immovable property and required by section by 1908 Act or transfer of property to be registered may be received as an evidence to the contract in a suit for specific performance or as an evidence for any collateral transaction not required to be effected by the registered instrument. By virtue of the proviso, therefore, an unregistered sale deed of an immovable property of a value of ₹100 or more can be admitted in evidence as evidence in contract in a suit for specific performance. Such unregistered sale deed can be admitted in evidence as evidence for any collateral transaction not required to be effected for registered document. When unregistered sale deed is tendered in evidence, not as an evidence of complete sale, but as a proof of an oral agreement of sale, the deed can be received in evidence, making an endorsement that if it is received as an evidence for oral agreement to sell under provision to section 49 of 1908. Now, my lord, next column. Another gentleman is quoting the line number. Shall I continue second round? Lord, proceed ahead.
No, we can continue. Second half we have, yes sir?
Previously, it was mentioned about stay article or hearing पर
अदर साइड का अपडेट भी नहीं हुआ है 4 बजे आपका मैटर कुछ भी ऑर्डर तो करेंगे इसमें लेकिन आप 4 बजे आइए
4 My lords, no.
You can continue in the second. Second आपने ऑर्डर 4111 वाले मैटर्स हैं तो उनको सुन के फिर हम सुनेंगे 2:15 बजे आई काम
Whatever is
2:15 हम नॉर्मली 2:30 तक आते हैं लेकिन 2:15 हम आ जाते हैं ठीक है
Lord, I request Lord that if possible, Lord, we can defer order 41 to 11 for tomorrow, Lord, so can complete this.
we'll see जितना